The question is that the motion be agreed to. Charles Chauvel.
Thank you, Mr Speaker. Mr Speaker, I just want to make a couple of points in the second reading speech. I differ from the Attorney-General in that I think it is fair to say on any objective reading of the bill that it is significantly reworked as a result of the scrutiny that it received in the Select Committee process. It is by no means accurate to say that it is somewhat or slightly modified. And let's just be clear about what the changes that were made in the Select Committee were. First, the powers of law enforcement are strictly confined to those that they were prior to the Hamed decision in the Supreme Court, not the enormous grab for power that was represented in the Attorney-General's first effort on this matter. There's a significant narrowing down of the definition of the term search, a removal of the outrageous reference that first appeared to the collection of information about any place, person or thing. That's the breadth of the power that would originally have been allowed under the National Party's initial proposal. There's an express preservation of the Section 21 power in the New Zealand Bill of Rights Act 1990 that any search must be subject to the reasonableness criterion contained in that section. If it is not, the courts will not uphold it. Again, another protection inserted at the Select Committee stage that would not have been there had National had its way originally. Thirdly, sir, there's a removal of the Attorney-General's attempt to nullify the discretion of the courts under Section 30 to receive such evidence as they think fit under the Evidence Act, notwithstanding the manner in which that evidence was obtained. We should leave these matters to the courts, not try to interfere with them as a Parliament. The second most significant change wrought by and in the Select Committee was that the retrospective nature of the powers contained in Mr Finlayson's original bill have been completely removed. Existing investigations and cases before the courts will be and must be untouched by this Parliament. The third significant change created by the Select Committee was to insist that the bill not apply for any longer than 6 months. The original proposal was 12 months. Parliament is going to have to get its skates on and do what it should have done a year ago and pass the Search and Surveillance Bill that sets out powers of search and also protections for those who are subject to those powers. It is outrageous that that has not yet been done by this Parliament and by this government. And finally, the Select Committee insisted that as far as past court decisions were concerned, where evidence had been admitted in good faith by a judge on the basis of good law applicable at the time, those decisions should not be able to be disturbed. Now, there are some who don't like that exercise of authority or recommendation by the Select Committee. They think that it should be possible to relitigate actions taken by law enforcement on the basis of an ex post facto application of the Hamed decision. Well, I say to those people this, sir, that would be dog law. That's like saying to your dog, bad dog, after they've done something that they didn't know was wrong at the time. Either you oppose retrospective application of the law or you don't. And in that regard, I want to quote what the Human Rights Commissioner said to the Select Committee when asked about whether or not existing court decisions ought to be preserved. One of the Human Rights Commissioners replied as follows: well, my view would be that the cases that have concluded have concluded. If the lawyers haven't raised the point, then it's passed and there would be no avenue to reopen the case. It presupposes, of course, behind your question, that the only evidence was the video evidence. So I can't see why the Court of Appeal would want to entertain appeals on that basis. So, sir, it's not in respect of that particular aspect of the recasting of the government's original bill any sort of offence to human rights to have protected existing court decisions in that way. Sir, I want to conclude this second reading speech by paying a tribute, but a limited tribute, to the parties in the House like Labour who weren't willing to simply write the National Party the blank cheque that they sought on this legislation a couple of weeks ago. And obviously the Green Party, the Māori Party and the Mana Party are in that category, not Peter Dunn, as was asserted in the Herald today in its editorial. I was at a public meeting with Peter Dunn the night of the bill's tabling where he was quite happy to write that blank cheque to the government, so we should get the record straight on that. I do want to pay significantly more tribute to the ACT Party for remembering its traditions and protecting civil liberties. I hope that with Mr Banks and Mr Brash in prospect as potential future MPs, that tradition is not in significant danger. But I want to pay the most tribute to my Labour colleagues for respecting their traditions of limited government. They could have chosen to leave law enforcement with no surveillance powers. That would have been the easy option, and it's the one urged by the Greens, the Māori and the Mana parties. But my colleagues avoided that trap. It would have been irresponsible at the time of the largest international event New Zealand has ever hosted to leave law enforcement powerless in that respect. And so the least worst outcome will be achieved out of this legislation, sir. As a result of the Select Committee process that the government was required to undergo, police will get only the limited powers that they formerly held, for 6 months only, and Parliament will be prevented from doing something constitutionally repugnant, that is, legislating retrospectively. Labour stood firm and achieved that outcome, and for that I express the deepest respect, gratitude and thanks to my Labour colleagues on this side of the House.
Cheers to Borrows.
Thank you, Mr.